This is the current federal tax developments for the week of June the 30th, 2025. Current federal tax developments are brought to you by your state society of CPAs. Med Zollers again from Phoenix this week, and we're looking at some developments that took place in the current week in taxes. Now, what we're not going to look at this week is anything new from the Senate. As I record this on Friday afternoon, still doesn't seem to be anything really happening in the Senate in terms of passing their bill. So doesn't look like we're going to have anything real quick on the new tax bill. So we'll talk about some other items. We are going to talk about a court case. We've talked about this whole dispute before, but we have a court that upheld the IRS's employee retention credit guidance that it did not violate the Administrative Procedures Act, and actually held about what I believe the courts were going to hold on this anyway. We'll talk a little bit about that. It's a case we've talked about before. We've been talked about a couple of times. It was a movement to try to get the courts to strike down 2021-20, IRS Notice 2021-20, and the only issue I had with that was always, okay, if they do that, then what? What happens next? And I never got a good explanation for that. And what happens next is becoming a big deal now because the clock's running out. And this week, I want to talk about the case of a taxpayer who, the only thing we got here is the filing of a suit against the U.S. government for their ERC refund claim. But the reason why the taxpayer had to file this week is important to understand because you may have clients that are in the same position. The clock is running out. So I want to remind you about how the clock works and the statute of limitation works, and why this particular company, even though their refund claim is only $56,000, which is iffy about having the finances work going to U.S. District Court, despite that, they really are, they in essence had to file to preserve their rights, because by today, Friday, when I'm recording this, had they not done anything, they would never get any of the $56,000. So we'll talk about that. We also have, out of the blue, the IRS updated the K2 and K3 filing requirements, FAQ, and they expand the exceptions to filing, and these expanded exceptions do apply to any 2024 returns you've not yet filed for a partnership or S Corp. So we'll talk about that. We have the taxpayer advocate releasing her fiscal year 2026 objectives report to Congress, and we have a case on the trust fund recovery penalty. What is responsible person and what is willfulness? Under Section 6672 of the Internal Revenue Code, that relates to that penalty that can end up getting somebody who has the authority to, and the capability and authority to make sure the IRS gets paid trust fund taxes. They can be on the hook for the whole thing. This is an issue that really does impact, especially any of you who are, let's say, controllers, CFOs, etc. You have that exposure, and it's important, if you have any friends that are in a position like that, to remind them of their potential exposure if the employer decides, well, we're going to go under, we can't pay all the bills. Hey, the IRS isn't going to stop shipping us goods and services, right? Shipping us goods to sell, etc. So we're going to pay our supplier and not the IRS. Yeah, we'll talk about how that is not so great if you're anywhere near the books, anywhere near the checkbooks, anywhere around when you determining who gets paid this week. So we'll talk a little bit about that, look at a case that goes into that. Well, let's go back to the employee retention tax credit. We're going to go look at the court upholding the IRS's ERC guidance. This case is one we've talked about before because we've been through a couple of times that we've had published requests for injunctions, etc. So we're back to this case of Stenson Tamadon LLC versus United States Internal Revenue Service. Case number CV 24-01123, PHX-SPL. PHX is Phoenix because it's United States District Court for the District of Arizona. And the opinion came down on June the 20th, 2025. And the decision provides insights. It's the first time we've really had a court rule on some of the challenges we've seen made to IRS's guidance regarding the Employee Retention Credit Program, and kind of outlines why my own thought is the challenges to this, the catch is, the problem is This particular item we're talking about here just tells us how the service will interpret the law and, basically how their position in court. It's not binding, and also gives us some safe harbors. So the court didn't find that it was going to have to knock that down. The court ultimately sided with the government. The IRS has the authority to issue interpretive guidance without formal rulemaking procedures. That's really become important because the IRS, the formal procedures getting to issuing regulations take quite a while. So, the court found that, if we're just going to say that, there'd be no guidance whatsoever, and that's not a better situation. So we're going to talk about this issue, but they do say that the IRS has to limit itself to interpretive guidance when it does this. So let's remind you about the ERC program. I'm sure you probably haven't totally forgotten about it, but it's there, the Employee Retention Tax Credit. It was established by the Coronavirus Aid, Relief, and Economic Security Act of 2020, the CARES Act. And it was modified in the interim. It was modified twice, once at the end of 2020, and then later on during 2021, actually 2 times, one time to expand it again and extend it for 2 more quarters. It got extended through the end of June by the end of 2020 action. And then next time to remove the 4th quarter for most companies. So it got hit a few times in all of that. But that's the act. So the CARES Act started it, we're there below. Now, the goal of the ERC was to, during the COVID pandemic, to stimulate economic recovery, support companies keeping people employed during that, and aid businesses that were negatively impacted by COVID-19. And it provided a refundable tax credit administered through the payroll tax system, which is going to cause us some quirks here, but that's a different problem, to employers who paid qualified wages despite being adversely affected. Initially, it was for wages paid from March 12th of 2020 to January 1st, 2021. It was later extended at the end of 2020 to cover quarters in 2021, and then in 2021 to extend it to cover all quarters temporarily, and then mainly backed off of the 4th quarter. So we got there. So it was retroactively terminated in Q4 of 2021 by the Infrastructure Investment and Jobs Act, except for recovery startup businesses. But that last part is going to kind of become an issue, but not really, because the quarter in question for what we're going to talk about here is the 3rd quarter of 21, not the 4th. So to be eligible for the ERC, you had to be carrying on a trade or business during the quarter, right? Your operation had to be fully or partially suspended due to government COVID-19 orders. This is for the 3rd quarter of 21. These were basically our rules. Gross receipts, if they were less than 80% for the same quarters in 2019. So basically, you carry on a trade or business and you meet one of the following 3 rules, right? So you had the full or partial suspension due to the government COVID-19 orders. That is, for the taxpayer in this case, what they were trying to get their refund under. Gross receipts less than 80% of the same quarter in 2019. The company in this case conceded they didn't have their gross receipts drop to below 80%. That's not what they were looking for to get their refund. And then finally, if the employer was a recovery startup business. And the company here says, yeah, we're not a recovery startup business. As we'll discover, the IRS thought they were asking for the refund as a recovery startup business. And we can talk about why they may have thought that. But essentially, we ended up with this issue. Now, the CARES Act authorized the Treasury to issue forms, instructions, regulations, and guidance as necessary. That is straight from the statute. In March of 2021, the IRS published Notice 2021-20, which was really mainly lifted from an FAQ they'd put on their website in 2020 under the program before it was modified at the end of 2020. But that came out, Notice 2021-20. It was a 102-page question and answer document that provided comprehensive ERC guidance, again, based on that old FAQ that was on the IRS website back in 2020. Now, remember, one of the big changes at the end of 2020 was during 2020, if you had gotten a PPP loan, Paycheck Protection Program loan, you couldn't claim the ERC. But at the end of 2020, Congress retroactively removed that restriction, only stating that you couldn't use the same wages to qualify for getting your PPP loan forgiven and getting the ERC. So Congress, just said you can't double up on that, but they did allow people to get it. That started what would be a big problem, because that meant that many employers retroactively qualified for this, which meant they had to file 941Xs. And if there's one thing the IRS really wasn't going to be able to do easily, it was process a flood of 941Xs, all of which had to be filed on paper and all of which have to be processed via paper. So that was kind of the fun part we were at there. Okay. Now, here's the plaintiff's challenge. Stenson Tamadon's LLC's argument. They are a tax advisory and technology firm. They specialized in filing ERC claims during the time period that credit was out there. Now, their compensation was success-based, as many of these were, right? They don't get paid until the refund is paid, and they would get a percentage of the refund amount. If the claim is disallowed, there would be no compensation to them if it turns out there was no valid claim. Now, they claim direct injury from the IRS position that unlawfully narrow or limit the availability of the ERC for businesses. And they claim that Notice 2021-20 was such an illegal action by the IRS because they said it did that. So their contention that Notice 2021-20 constituted improper legislative rulemaking. Now, by legislative, we mean that the IRS essentially setting down the law, not simply interpreting or giving their view on what the law is. Because again, if it's just their view, I have my view, they have their view, we dispute that, we go talk to the court. And the court will take a look at both our views on the law as well as how our facts apply to that. Now, Stentam, and they're referred to in this case as Stentam because that's what they appear to go by, they argued that what the IRS did bypassed Administrative Procedures Act notice and comment requirements. Bottom line, they're stating the IRS, before they could issue something like Notice 2021-20, would have had to go through a formal notice and comment period. Basically, the process one goes through for regulations. They also contended the notice was arbitrary, capricious, or beyond the IRS's statutory authority. And they argued, and this is part of trying to say why it is a legislative work they did here, that it defined various terms, identified factors or elements necessary, set minimum threshold, and imposed new related record-keeping requirements, thereby restricting the ERC to fewer businesses than Congress intended and creating substantive duties. And again, IRS cannot do legislative rulemaking without going through that whole notice and comment procedure. And Stentam was also claiming that they had no authority anyway to do what they did in this case. Okay. Now, the claims asserted for the APA violation, they said they violated APA's notice and rulemaking authority. They argued that there was an arbitrary and capricious agency action. There was unlawful agency action in excess of statutory authority. There was an ultra vires action. And there was a fifth mandamus claim that was dismissed after the IRS lifted the moratorium on processing ERC claims. You may remember that when we first talked about this case, the issue there was that the IRS had issued this moratorium. And Stentam was trying to get that moratorium, in essence, force the IRS to stop doing it. And a few other things. Well, obviously, the whole question here about whether, the issue about whether that suspension had to be lifted became moot once the IRS lifted it. And as you may remember from the first Stentam decision, the court hinted strongly that it might be in the IRS's interest to rather quickly get rid of that suspension, because while they said it was a reasonable thing to do for a time period, that time period was not forever. So the court's analysis, they're looking at standing. Does Stentam have standing to bring this suit? And, did they bring a suit for which the government has waived its sovereign immunity? Now, the government said Stentam didn't have standing. They argued the injury that they incurred flowed from the statute itself and not the notice. Now, the court had already kind of ruled in this area in the first case, right? Because if Stentam had no standing, then it wouldn't have mattered about the fact the notice was out there and whether or not, and I should say not the notice, but the suspension, it would be irrelevant if they had no standing, right? But the court said, look, Stentam demonstrated for constitutional standing that they had an injury in fact because the notice was used to deny ERC claims resulting in lost funds for Stentam. Assuming that the IRS committed misconduct, because that's the allegation here, and for standing, we will assume for now they did, the injury was directly linked to the IRS's conduct, right? So fine. That means that we should go, they have standing to bring that claim. The IRS had tried to argue that because they weren't being paid the ERC, it wasn't, they had no right to the refund claim directly from the government, that they really didn't have standing. Next was prudential standing, right? The court reiterated the ruling it had earlier that professional tax preparation services are essential in carrying out Congress's intent for ERC, and that gave Stentam standing also to get into this. They're involved in the process. They're not just this oddball third party out there. Okay. The government also argued lack of jurisdiction due to sovereign immunity. They asserted that there was an adequate alternative remedy through tax refund lawsuits. Now, we'll get to this part with the next thing we talk about. But they're saying, no, here it is. If we're not giving people their ERC claims, then the remedy is that a suit is filed in U.S. District Court, and we go to trial on the issue of whether or not it was, we properly denied the claim. We interpret the law. Now, the court had previously rejected this. Here's the problem. They said, there is no relief available for Stentam via any sort of lawsuit, right? While the taxpayers their clients could bring refund suits, and we'll talk about the fact that probably some of them are going to have to start doing that here shortly or give up their claims entirely. That doesn't work for third parties who may be affected by their handling of the program. Stentam had no direct way. There was no alternative remedy. Basically, suing the IRS for this relief was the only possible way they could get a remedy. Stentam was challenging rulemaking under the APA, making the APA the appropriate avenue, and the notice was considered a final agency action for which there is no other adequate remedy in court. So, Stentam was allowed to bring this case, so they had standing. But now we have to go look at the case itself. Now, the key issue is, was this a legislative rulemaking or was this an interpretive rule? Legislative, we have to go through a lot of hoops. Interpretive, if they're merely interpreting the law, then yeah, they don't need to go through all those hoops. So the question says, do the rules the IRS issued in Notice 2021-20, do they require notice and comment procedures? Are they legislative rules? Or are they exempt? Are they interpretive rules? Now, the court notes interpretive rules do not have the force and effect of law and merely explain but do not add to the law that the courts will use, right? While legislative rules create rights, impose obligations, or affect a change in the existing law. That's when Congress, delegates to the IRS, writing various rules, etc. That was what got them in trouble with the listed transaction issues, was they were saying there, the court did hold that, what Congress had delegated was effectively legislative, and they couldn't just issue notices and create listed transactions. You may remember that from, I think that was 2 years ago, that we had all of that come up. Okay. Now, these taxpayers are located here in Arizona, actually here in Phoenix. So any appeal of this case would go to the Ninth Circuit. So the court looked at the Ninth Circuit's framework from the hemp case to determine if we have a legislative rule. Okay. So, in the absence of this rule, would there be no adequate legislative basis for enforcement action? In essence, we need a legislative rule because otherwise you couldn't move forward on the statute. And Stentam specifically pointed out household employers. They said, well, it said if you're a household employer, you don't qualify for this. And if you also have a trade or business, you can qualify, let's say one where you report the household employee on 941 as well, you could qualify, but you can't qualify for the household employers, only the employees that are involved, only the employees that are involved in the trade or business. And it said FAQ number 6. The court said this was simply an interpretation of trade or business based on long-standing court cases. This was not breaking new ground. Congress used the term trade or business. The IRS's interpretation here was not exactly earth-shattering, wasn't coming down a brand new theory, was simply repeating what we've had before. Now, they also said, well, FAQ 10 said that, your order must be issued by an appropriate government authority that had, in the IRS's views, direct control over the taxpayer. The court found this was a natural interpretation of the plain meaning of the text. By definition, adequate legislative basis, meaning they're saying, remember the rule here is if the code itself is clear, or in this case, the non-code for most of the ERC, because it didn't get in the Internal Revenue Code until the third quarter of 21, which I guess is the one we're disputing here. But in any event, if the statute is clear as written, not ambiguous, then that's the answer. Saying that would be the answer we would come to because it's not ambiguous. So bottom line, don't worry about it. Partially suspended, the nominal portion standard under FAQ 11. This is where you may have heard about the 10% test. Now, the taxpayers said, Stentam saying, look, they just established this 10% number out of thin air. But the court said that was a safe harbor. The notice itself allows that if you don't meet one of the 10% guidelines, you can have a facts and circumstances test, to show how there was a partial suspension, even though you couldn't show a 10% reduction in hours, right, etc. All of those things, any of the 10% activity tests. They're saying none of this said that if you go below, if you can't get somebody above that, you won't get it. Now, the court did agree that the IRS in exams may very well be taking the position that if you can't meet the safe harbor, we're going to disallow and we'll see you in court, but that's okay. And in facts 14 through 16 of voluntary suspension and comparable operations, again, these were obvious and natural interpretations of the language Congress wrote. Again, if Congress has written unambiguous statutes, that's it. So the court's essentially saying, we would have ruled this way. Regardless of whether the IRS said this or not, they're right. So that's kind of a backdoor way we got it. Now, the record-keeping requirements in FAQ 70 and 71, they said, look, that's just a natural extension of the requirements to have adequate records found in IRC Section 6001 and the underlying regulations. This just clarified, how those apply to this situation. It did not impose brand new record-keeping requirements. You got to be able to prove you qualified for the credit. 6001 requires that of the taxpayer. They've got to have adequate records to back up this claim, right? The overall conclusion, the IRS was interpreting, not modifying or supplementing the statute. Okay. The agency explicitly invoked its general legislative. So number 2. Okay, so on number 1, that doesn't make it legislative. But there are 2 other ways it could come through. Did the agency explicitly invoke its general legislative authority? And there is a general clause. We had that brought up years ago. It was in the Mayo Clinic case, as I recall, Mayo Foundation case, I should say. Where that was discussed, that the IRS has, a broad power. There's a segment of the Internal Revenue Code that simply grants the agency the right to issue guidance, as needed on the code. But the IRS didn't invoke that here. They never said that they were doing it under that legislative authority. They constantly referred to the notice as guidance, not as a legislative authority or requirement. Okay. Did the rule effectively, now the third way in, it could still be a legislative rule if it effectively amends a prior legislative rule, makes changes to that. But the court rejected this as well. Interpretive rule that supplying crisper and more detailed lines does not become an amendment. Otherwise, they said we would just, the IRS would be limited to only, basically parroting exactly what was in the statute, and that wouldn't help anybody in interpretation, right? So the court found the notice was an interpretive rule despite its practical binding effect. The court admits that the likelihood is if you're not inside the safe harbors, or if you don't meet all the issues, the IRS's interpretations that are in this notice, that you're likely to have your claim disallowed. And, unless you can get the IRS to change that on appeal, which, as we'll discover coming up, just getting an appeal heard before the statute runs out is going to be a big problem. You really have no practical recourse, because if you're talking about, let's say, in a case of an ERC claim of $15,000 for the quarter, no way are you going to be able, it's going to cost you more than that to take the claim to the district court. So bottom line, there is no practical, which they said that may be true, but you still had the legal effect. Legally, it's not binding. Legally, you could challenge it. Legally, you could win it. You may not be able to practically do that, but hey, welcome to the U.S. legal system. You may be totally correct, but you might find that actually litigating would cost so much that there's no real way for you to get relief. That's the court systems, guys. That's how that works. Okay. Now, they also said, well, what about the attack that it violated the APA section 7006 2A? Was an arbitrary and capricious agency action. Even interpretive rules can be struck down if the action was arbitrary or capricious. Now, in this case, they distinguish this from CIC services, which was that whole bit about listed transactions cases. It distinguished it, noting that 2021-20 interpreting an organic statute itself and involved policy, not factual determinations requiring data. So it wasn't like that case because, Stan Tam mentioned that. And applying that to Notice 2021-20, he found interpretations were a difference in view, not running counter to the evidence. And the IRS considered important aspects, so it was not arbitrary or capricious. That is a pretty high standard, so it's a little tougher to get over that. And finally, remember, Stan Tam claimed they were acting beyond their statutory authority. And the court said, look, it would have to be a legislative rule for them to act beyond their authority. And we've already told you it's not a legislative rule. It found that the IRS interpretations did not depart or change the statutory text. The major questions doctrine and Loper-Bright decision, which the Supreme Court has applied and which Stan Tam mentioned here, were irrelevant. Remember, Loper-Bright deals with whether you must give what level of basically deference the courts must give to binding guidance of the agency. But the court said this notice has no force of law. It is entitled to zero deference. When you go to court, this is merely the IRS's position. The court is under no obligation to, kind of lean that direction on what the proper interpretation of the law is. Simply the IRS's litigating position. Right? Not really something that, so it's not beyond the IRS's statutory authority. They have a right to go to court, right, and challenge on tax issues. That's not going beyond it. So the court denied Stem 10's motion for summary judgment and granted the the United States cross motion for summary judgment dismissing this out. Now, the court said it is difficult to distinguish rules, but it said the problem is practical effect does not mean it's legally binding. You have a right to go to court, and you have a right, if you went to court, if you paid the attorney and went to court, and we're going to assume you're right and the IRS is wrong, you'd get the money, right? If the IRS interpretation was found to be an error by the court, you'd get the money because it has no deference requirements. It's not a legislative rule, right? So the court using the standard rules of statutory interpretation determines that now the better way to read this case is do this. You have a right to go to court. You may not have a practical right because it's ridiculous to spend, $30,000 in fees, discovery costs, etc., to try to get back 10. But that doesn't really matter under this, right? That's it. If that mattered, there'd be a whole lot of issues in U.S. courts that could be interesting to deal with. They said it's understandable why it was done this way. They're under pressure to issue timely guidance because time was of the essence. The ERC program was passed very swiftly. Congress made rapid-fire changes in the program. Issuing it as interpretive fact was a permissible exercise of agency discretion. And the key takeaway is, while the IRS guidance, even in an FAQ format, has substantial practical implications, the court may uphold it as a valid interpretive rule if it genuinely interprets existing statutory language and doesn't actually, get new law. Our job in this case, which is what I have said about this from early on, is to make arguments based on the statute. Notice 2021-20 was the IRS's view, and certainly I'd consider, is that view valid? But, if you did a separate analysis, you come to a different one, then, you get in front of the court, the IRS gets in front of the court, and we decide it. Each one has the same level of deference, which is none, right? You'll just make it there. So, yeah. So in any event, we're there. And I'm not sure this type of case matters anymore because let's go on to the next development. We have a taxpayer who is filing an actual refund claim in U.S. District Court in Alabama as the IRS's failure to act on its appeal filed within 30 days after they received their notice of denial of their claim. The IRS hadn't acted on it, and the 2-year statute to take the IRS to court to be able to challenge that denial was running out. And this is why the Stentam case at this point almost is totally irrelevant, right? It doesn't really matter. People are going to have to start taking these actions, right? So the case citation is American Lighting Company, Inc. versus United States of America. It was a complaint filed in the U.S. District Court for the Northern District of Alabama, and it was filed on June the 25th. It highlights a critical procedural issue for ERC claims, which is that once the IRS denies your claim, there is a 2-year clock running. And while you'll say, well, I can go to appeals. In the case of a IRS, notice of deficiency, issuing that, when they're saying, we're going to, they issue a 90-day letter, yeah, you go to appeals and the clock's not going to run out on you. The clock can run out on the IRS. Because remember, the IRS is the one asserting and trying to change the situation. When you do a claim for refund, that's exactly reversed. You're now the one the clock can run out on. And this is the problem we're hitting. The taxpayer was compelled to file this lawsuit just 1 day before the 2-year statute of limitations would have expired. They had to file this week or their third quarter 21 refund claim was not going to be in existence anymore. There's going to be no way to get paid if they hadn't filed the suit, which kind of put them in a bad position because the number here is right on the edge of what I would think might make sense to take to district court. So let's talk about the general 2-year statute. It's under Internal Revenue Code section 7422. An action for a civil action for a tax refund. First, you have to file an administrative claim. You cannot go to court unless you wait 6 months after that claim is filed, or if the IRS notifies you of denying the claim within the 6 months, or at any time thereafter, then we flip to the other deadline, which is that you must file your suit within 2 years of the denial date. Okay. Now, American Lighting's claim for the third quarter of 2021 was denied by the IRS on June the 26th, 2023. They filed their lawsuit on June the 25th of this year. That was exactly 1 day before the 2-year anniversary of the IRS's denial. And at that point, if they had not filed essentially right away this past week, there would no longer be a case. Okay. Now, the complaint stated that it was filed within 2 years after receiving his notice of disallowance and filed more than 6 months prior, and duly filed more than 6 months filing of the complaint. The notice has been out there. The IRS is disallowed, so they meet the requirements. They can bring this case in court. Okay, they met both. Now, what about that third quarter 21 denial? Because American Lighting had been paid ERC refunds for each prior quarter the ERC was there. So they had gotten it for all of 2020, and they had received refunds for the first and second quarter of 21. But the third quarter of 21, the IRS rejected their claim. They said it exceeded the $50,000 maximum for recovery startup business. Now, let's talk a little bit about what the 941X said, because one problem we have, some people are always of the mind that when you file a claim or you do anything else with the IRS, you only give the minimum amount of information required. And the 941X really doesn't require you to provide, volumes of information about why you qualify for the refund. You are told to explain it. But in this case, all it said was, the company discovered after the 941 was filed for the quarter that they qualified for the ERC, and they're filing this to get paid. Did not give any hint about what method they qualified. Remember, there are 3 ways to get there. They could have gotten there by, a drop in fees. They could have gotten there by being a recovery startup business, or they could have gotten there by, having a full or partial suspension. Now, the IRS picked recovery startup. Now, American Lighting, who never had a chance to submit, never got questioned and asked for information by the IRS to support their claim, they said, no. We weren't doing this on a recovery startup. We were going to do this under the full or partial suspension. And they said, hey, the IRS had paid all of our other quarters. And I would presume their 941Xs for those other quarters probably all had the same statement on them, right? It was done the same way. By the way, we know what the 941X said because that's one of the exhibits that was filed along with their, with their complaint. So we can see those and see the IRS notice. We have all of those things in front of us. Okay, so basically, the IRS paid every other one, but they're not paying this one. I have talked to a lot of people who've had clients with ERC claims that have had that experience. The IRS paid claims, but then at a certain point, they just stopped and they're looking for it. Now, the IRS did remember, you have to file administrative appeal. After the IRS disallowed, American Lighting stated it appealed the decision within 30 days of the date of the disallowance, providing proof it was not a recovery startup business. Now, interestingly enough, they didn't say they provided proof that they qualified somewhere else, but again, the IRS hadn't really contacted them yet. So in theory, it would have been, the theory when these things happen, according to the National Taxpayer Advocate, we'll get to that part here later. We talked about that last year. It goes back to exam, who then starts asking for data. But in any event, they never heard anything from the IRS, right? No response from the IRS whatsoever. The IRS had effectively ignored the appeal. Now, while they don't say if they asked for an extension of the statute, my guess is with the IRS ignoring everything, they very well might have asked for an extension. But here's the catch. The IRS doesn't have to grant the extension. It's kind of like you don't have to grant it on notice of deficiency issues. They don't have to grant it here. In the IRS notice of deficiency statutes, of course, then they'll just issue, the formal notice of deficiency. And, it's up to you then to go to tax court. We're running out of time. If they don't extend the statute. In this case, though, now you're the one on that side. You need the statute extended. The IRS doesn't have to extend it. So really, if they just ignore you for the entire 2 years, they can win by running out the clock if you're not willing to go file in court. That may not be a fair law. That may not be a way the law should be, but that's the way the law is. Okay, we're very, very much in there. Now, this is a key issue that the National Taxpayer Advocate highlighted a year ago. In August of last year, remember, we talked about that. The National Taxpayer Advocate had issued a report and a blog page that specifically called the IRS out for the ERC program and specifically noted about this huge problem that if they issue a denial, which they do automatically, this almost certainly got an automatic denial under the program. And I suspect that it was deemed to be highly likely to be a not valid claim, probably because A, most places, as we get further into this, there were fewer and fewer orders that applied. The taxpayers were in Alabama, right? It seems unlikely that they would have met that requirement. They also weren't claiming a reduction in revenues, and, the IRS could kind of, by that time, probably have seen their, calendar year filings or whatever year filings they had and noticed that their revenues weren't down, so that probably wasn't it. And so they just said, well, you're not a recovery startup business. Okay, that was where they go. But as I noted, the 2-year time frame just keeps running. So, the IRS determined it's probably going to be invalid. They deny it, and they basically ignored it, largely because they are, flooded with whenever they've done this, we get automatic appeals filed, because why not becomes almost what people think. And my guess is that they just simply never got to this thing, right? And as National Taxpayer Advocate stresses, going to appeals does not extend this time period to file suit or for the IRS to issue a refund. In fact, the law bars the IRS from issuing a refund once that 2-year period has gone by. So had they not filed suit, I don't care what would be later found out. Congress said IRS is barred. They cannot pay a refund if that 2-year statute had expired. Law simply bars it. So now, right, if the IRS office were to agree with the taxpayer after the 2-year period expired, the IRS could not issue that refund unless a Form 907 extension had been agreed to and signed by both parties. And remember, the IRS doesn't have to sign that form. You need to ask for it, but they don't have to sign it. So the commencement period, 2 years following suits, runs from the date on the top right-hand corner of the first page of Notice of Claim for Disallowance, which again, in this case, had, the date that was 1 day short of being 2 years prior to the date they filed in the courts. Now, the advocate noted this was an unusual process. That the IRS had put the cart in front of the horse. They disallowed when taxpayers went to appeals. That was when the IRS would finally assign it to an agent. If you were automated, under the automated system, if you were deemed to be likely invalid, then you got assigned, and at that point, they would start working the case. But remember, the 2-year clock is running, and if they just don't get to it within 2 years, IRS wins unless you file in court, right? because the IRS conducted a risk scoring analytic process. The taxpayer advocate notes how this works, and obviously in this case it didn't, but how it should have worked in theory was that when they respond to that disallowance notice, their response is reviewed by a revenue agent in what becomes effectively the exam, right? Before potentially being forwarded to appeals after the agent decides, okay, should we grant it or not? If the agent decides, hey, you qualify, then they override the original disallowance and you get your refund. You don't go to appeals. If they deny, then at that point, you have the right to move on to appeals. And then you still got to get an appeals hearing, and the 2 years is running out in the background. And we did have the unclear communications. Remember, some people got the disallowance letters that omitted the paragraph highlighting the process filing an appeal. And they also offered unclear explanations of the reasons for disallowance, which created confusion for taxpayers. In this case, the IRS gave a notice saying you're not a recovery startup business. But while we can say that the taxpayer didn't tell them why they qualified, there really wasn't much reason for the IRS to assume that they were talking about that. You could have disallowed it saying that you stated no reason that you would qualify and provided no evidence for that reason. So that's kind of where we're at. Now, remember, our key problem here, the statute of limitation for filing a refund suit does not pause or extend during administrative appeal. You gotta be, your clients that have gotten disallowance notices on ERC claims, again, go get that date. As this case proves, there are people with dates running out now. They have got to talk about, do we go to court or not? The first thing we would obviously try to do is consider getting a 907 signed by the IRS, but you may have trouble getting anybody's attention. And again, they don't have to do that. So, I would probably suggest, if you have the problem, I would strongly consider, talking to the congressperson that represents the taxpayer, and essentially, getting them to try to intervene with the service and, do those sorts of things. It may help if your congressperson or senator is on the tax writing committees. That would help. But that's probably it. You got to tell clients, you got to give clients the bad news. Got to say, look, this may be wildly unfair, but when that 2 years goes, the IRS does not have to do anything during the 2 years. And when that 2-year clock runs, you either have to file in court, which, as attorneys have told me, the district court, you expect to get insanely expensive once the discovery process starts and all that stuff gets going, because it's more formal than the tax court in that regard. It could be very expensive to litigate there. And yeah, if you got a $6 million claim, sure, you'll litigate you'll be able to pay for litigation. But if you got $15,000 claim, I'm not sure it makes any sense. Also, make sure that you have the records of all communications, filings, and attempts at administrative appeal to demonstrate that you did everything right in place. But like it or not, as impractical as it is, you've got to tell clients they may face the question of, do you want to file in the district court, understanding that you may pay out more in legal fees than the refund amount if you win the case? Now, you could lose the case and just be out the legal fees. Or do you just want to let it go and disappear and forget all about it and just not worry about that quarter? So, mess. Hey, K2 and K3, we can't stop talking about the K2s and K3s. Well, the IRS has decided to update their filing requirement FAQ. The weird part about this is they are doing it here in June. And remember, before the extension date, these S corporation and partnership returns were due back in March for calendar year entities. And while a lot of them went on extension, probably most of them did, I think there have probably been ones of these filed in the interim, but now we get an extra exception. So if you have any, and I'm sure you have a few at least, S corps or partnerships that have not yet filed their return for the year in question for 2024, you can use this exception if you want to. We'll talk about it. there's a couple of changes here, so might get you out of filing. So this comes from the IRS website pages for the Form 1065 K2 and K3 filing requirements, either the 1120S or the 1065 ones, right? Either one of those. These are June 10th, 2025 revisions to the web page. That's what's also weird about this. You've got to go back and keep up on the web page to really be aware this change has taken place. I finally noticed it because I got what was it? One of those PPC 5-minute briefings where they mentioned it. That's the first time I had seen any service mention this issue. And it's like, yeah, I went back there and yeah, it's changed. So there are reasonably significant revisions to the filing exceptions for the K2 and K3. That is the partner's distributed share of international items for the K2, right, for that overall, and the partner's share of income, deductions, and credit international, the K3 that goes to the partner. The K2 is everybody, the K3 is to the partner. And these changes apply to both Form 1065, the partnership return, and 1120S, the S Corporation return, for tax year 2024. It's like late in the game, but we've got this now for this year. It is meant to expand the applicability of the domestic filing exceptions and introduce a new small entity exception that could potentially reduce your compliance versions. Now, both of these are not absolute, so they're both going to be subject to the simple flaw that if any partner asks you for their K3, then you're not going to be able to use the exception next year. So be aware that it's not perfect. So basically, the purpose of K2 and K3 is to report items of international tax relevance from the passenger entities to their partners or shareholders. There was a prior domestic filing exception. Generally, a domestic partnership, we'll talk about partnerships first, was exempt from filing Schedule K2, K3, or furnishing a K3 to a partner unless requested after 1 month date if 4 specific criteria were met. The partnership could also not be a qualified derivatives dealer. We're going to find out that we're going to modify those 4 criteria, 1 in particular, and we're going to add a new category. So we've expanded that filing exception, and we created a new small partnership K2 and K3 filing exceptions. And we're going to have a similar set of changes to S corporations. Okay, let's go. So to qualify for the exception, let's go through the whole rule, right? First rule, which is not changed, is the partnership must have no or limited foreign activity. So either there is no foreign activity during 2024, no foreign activity of any sort, foreign taxes withheld, foreign income, nothing, no foreign activity whatsoever. Or if foreign activity exists, it must be limited to passive category foreign income, upon which no more than $300 of foreign income taxes are treated as paid or accrued by the partnership. Right? So passive in this case doesn't mean 469 passive. It means portfolio style income. I love how that goes for the most part. And also, and the taxes were reported to you on a 1099 or a K1 from a trust, right? Or a trust or another partnership. Won't be from an S Corp because, basically, or it could be from an S Corp. No, it won't be an S Corp because partnership cannot own shares in an S Corp. You have a C Corp if they do. That's no problem. Foreign activity includes foreign income taxes, foreign source income or loss, or ownership of foreign entity. So there's your first category. The only foreign activity you could have would be like up to $300 of foreign taxes withheld on dividends. That would work, okay? Now, the other things you need is we have an expanded U.S. citizen resident alien partner rule. All direct partners must fall into an expanded list of U.S. persons. And the expansion is what's unique about this. Your partners must be a U.S. citizen or resident alien individual, a domestic decedent's estate or trust with solely U.S. citizen, resident alien individual, beneficiaries, grantors, an S corporations, a single member LLC, disregarded entity where the sole member is one of the earlier things listed. Or here's what's new. It can also be a domestic partnership whose direct partners themselves consist solely of the above U.S. individuals, estate, trusts, S corporations, or disregarded single member LLCs. you're allowed to go one level down, right? It does not appear you can go more than one level down. So if that partnership that owns an interest in your partnership itself has a partnership part, you can't go look at that. So, but you are going to go ahead and, see the others. So it does mean there. Now, that's something that was in the exception for the first year of K2, K3. You just could have no direct or indirect partners. It was a bit broader who didn't meet the categories. They're not fully restoring that rule, but they're slightly. So, if you have a not too complex structure, but you have a partnership that's a partner in the partnership you're doing, then you can take a look at that partnership and just make sure it has only the other types of, all of its partners are the other types of owners. So you go one level down. Okay. Now, the other qualifications, this is unchanged. These two are not changed at all. The partnership must provide a notice and attachment to the K1 to partners by the K1 furnishing date, stating they will not receive a K3 unless they request it, and it can be done with the K1. And no 2024 Schedule K3 request must be made by the 1 month date. And the 1 month date is 1 month before the date the partnership files Form 1065. For 2024 calendar year partnerships, the last day, it could be, if they file an extension, be August 15th of 25. So anything comes in after that date, it wouldn't require you to file the K2. In essence, you could still meet this exception. However, if in a prior year you got a K3 request from a partner, that's considered to be a request for this year and you can't qualify. Okay. Now we're going to talk about the small partnership exception. This is brand new. And it's looking to align with Form 1065 Schedule B Question 4, which tells you when you don't need to fill in the Schedule M2, M3, whatever. The balance sheet, you can keep all those things off. Where your total receipts for the year less than $50,000, your total assets at the end of the year were less than $1 million, Schedule K1 filed for return and furnished to partners on or before the due date of the return, and the partner is not filing or required to file Schedule M3. You are still required to notify the partner with the K1, right? That rule's still there. And S corporations get the same requirement. Again, basically based this time on question 11, Schedule B, where the corporation's total receipts must be less than $50,000 and total assets must be less than $250,000. So bit more restrictive there. And again, notification has to be made with the S Corp K1. The general rule doesn't really change for S's because, again, you cannot have a shareholder in S Corp that's a partnership. So that rule can't map over here. If a partnership qualifying under the expanded domestic or small exception or S corporation receives any K31 from a partner or shareholder on or before the 1 month date, you got to file everything, right? You're required to file tax year 2024 schedules K2s and K3s. You got to do it. So again, if you get that request before the 1 month date, now remember, under the current rules, everybody I assume by now understands this. Under the current rules, you're not required to tell them you're not sending a K3 until you send them the K1. But they have to tell you they need a K3 1 month before you file the 1065. So that, I know how absurd that seems, but that is the rule. Okay. So essentially, don't wait. Just assume they won't. If you need a K3, you send them and say, I need a K3. Okay. Now, if you receive it after the 1 month date, you still meet the domestic small filing exception, assuming you qualify to begin with. You're not required to file the 2024 K2 and K3 to the IRS or furnish a K3 to any non-requesting partner shareholder, but you still got to file the requested K3 to the requesting partner shareholder, and it must be done by the later of the 1065 or 1120S filing date or 1 month from receiving the request. I never quite understood that because, if you get it, if they give you the request 1 month before you file the 1065 or 1120S, then you can't qualify for the exception. So obviously it's going to be 1 month from the request date. It's going to be your date for giving them the K3. Remember, in that case, K2s and K3s, are only required to be completed for parts and sections that are relevant to the requesting partner or shareholder, and no other parts or sections need to be filed with the IRS or furnished to anybody else. So just fill in the relevant parts and we're fine. Okay. So big takeaway from this is it does affect 24 returns. So if for some reason you didn't qualify under the first rule, let's say you had, let's say, we have foreign taxes withheld of $500, that would take us out of the first, of the standard rule. But we are a small partnership under that rule. We don't need to do balance sheets. Then we could qualify again. That's really the type of thing we're going to do it, because something's going to push you out of the first category, right? Or you have a disqualified partner, but you're small. You can make it. You want to review each client's specific circumstances against this updated criteria if you're going to try to avoid filing this, if that's your goal. Now, I know some people have just decided, look, it's more work to figure out if I don't have to file it than to just check the box in my software that says all activity in U.S. and have it just issue and blast the K2s and K3s. And I know that because for clients I don't do the partnership return on, but an individual return, I've gotten a number of those, right? Just, hey, it is arguably simpler in many cases, just do it. Don't worry about the other issues. But if you do worry about that, fine. Always pay close attention to the definition of foreign activity for the expanded domestic exception, because foreign activities is where you're likely to get in trouble there. And understand the broad eligibilities on the partner types. It's not really expanded shareholder type for the most part, but partners it is. Be aware of the threshold for the small entity exception. Like you have always, worry about that 1 month date for that issue. You might want to communicate with partners and shareholders regarding K3 notifications and request procedures to ensure compliance and avoid unnecessary filing. And remind partners and shareholders that K3 information generally needs to be requested annually unless a specific multi-year request is made. Okay. Next up, the Taxpayer Advocate released her annual report of objectives to Congress. So this is the National Taxpayer Advocate Fiscal Year 2026 Objectives Report to Congress, found at http:// all that neat stuff, www.taxpayeradvocate.irs.gov/report/2026 -objectives-report-to-Congress/ right, issued on June the 25th. This is a statutory annual report that's required the National Taxpayer Advocate issue to Congress. It outlines objectives for the upcoming fiscal year of 26 and includes analysis of recently completed filing season. So what does the Taxpayer Advocates, what's their objectives for next year, which will include the next filing season, and how did this year go? This provides context on the IRS performance and taxpayer challenges, including systematic advocacy and research objectives of the agency, of the advocate. So what about the review of the 2025 filing season? The Taxpayer Advocate decided to call it a measured success. It was smooth for most taxpayers, and it did mark the third consecutive year of approved taxpayer service since the COVID-19 disruptions. Well, yeah, hopefully we're better than that. That would be it. Over 95%, and here's the key achievements, over 95% of individual returns are filed electronically, with most processed promptly. More than 60% of taxpayers receive refunds, primarily within the standard time frames. We added 22 more forms to be able to be e-filed this year, and the IRS did. All of those things were there that we had in that realm. Okay. They had improved phone service on the account management issues, right? They achieved an 87% level of service with average call wait time of 3 minutes, meeting its 85% goal, and expanded online account functionality. Taxpayers could download 9 times information return and access new features, payment plans, offering compromised pre-qualifier, secure messaging, and view 21 additional digital notices. And there were extended Taxpayer Assistance Center hours. And they said they attributed that to extensive IRS advanced work, hiring, training, and IT. No significant tax law changes in 24 because that generally disrupts things. And the fact it was a large IRS workforce. That's hinting at a complaint she's going to have. And that complaint is going to be directed at Congress, shall we say. Well, Congress and the administration. Suspended returns. Here's what the systematic issues. Over 13 million individual returns were suspended with 3.4 million were suspended at some point in the process, and 3.4 million of those were suspended for error resolutions or potential liability theft as of April the 18th, 25, the end of the season. There also were limitations of the telephone level of service metric. When measuring success, they excluded calls routed to compliance functions and automated systems. They weren't counted in concerning success. Only 32% of all calls received were answered by an IRS employee. Non-AM lines, Taxpayer Protection Program line, which had 29% of the lost level of service metric, and installment agreement balance due line, 40% line of service, level of service metric, were far below the reported IRS numbers. Okay. Noted that there is a correspondence and meta-return backlog, unprocessed inventory of 3.8 million of such returns on April 18th of 2025. Also, problems with identity theft victim assistance. There are delays there. Resolution of these cases continues at a glacial pace. It averages 602 days, nearly 20 months to resolve one. The document upload tool has back-end problems. You can upload stuff to the IRS, supposedly the person working the case. While submissions are electronic, the IRS doesn't have any back-end system to process them electronically, requiring them to effectively manually print out whatever you upload and then route the paper to the person. There's online account functionality gaps. The current digital offerings, while expanded, are limited, often forcing users to traditional service channels. ERC processing delays. Hey, we were just talking about that, right? The average processing time was approximately 546 days in 2025. And the IRS communications regarding disallowances have been unclear. And finally, systematic issue, workforce reductions. Workforce has been reduced by more than 25% since the beginning of 25, primarily via employee departure incentives, raising questions about how that's going to impact things going forward. Now, they have systematic advocacy objectives for 26. These address challenges from the filing system and align with their influence on tax administration. They're going to be looking at advocacy to improve automations and metrics to enhance the taxpayer experience, Objective 1. The taxpayer advocate wants end-to-end paperless processing and enhanced metrics. Service completion rate to evaluate the overall taxpayer experience, not just connection rates. Prioritize the Taxpayer 360 initiative to have comprehensive taxpayer data for customer service representatives. Okay. Enhance the IRS online account functionality. Aims for a digital-first strategy to allow taxpayers to conduct all transactions online. Basically, like your bank allows you to do everything online if you're capable. Maybe the stuff the IRS does allow you to do online is very convenient, very helpful. But there's a whole bunch that's not going to work for you. You got to go through other methods. And improve identity verification for online enrollment. A lot of clients still have problems getting ID.me to work, right? That's still there. They also need, the third objective is to reduce processing time from 602 days to 120 days by the end of the year, or 90 days or less by the end of 2026. And in the objective 6, skipping over a few, complete processing of all employee retention claims to ensure taxpayer rights protected. Aim to process all the claims by the end of calendar year 25, and prioritize hardship cases and track claims that are affected by the 2-year statute of limitations. The IRS needs to be working those appeals and getting something done, or at least offering to extend the statute. None of which really is happening right now. Remember our second development this week. Their research objectives going to focus on understanding how the IRS procedures affecting taxpayers improve operations. First, they're going to explore ways the IRS can use modern technologies to improve taxpayer services. The low call answer rates, 32%, and misleading, level of service metrics have been using is a problem. They advocate leveraging artificial intelligence for effective caller authentication, automated issue resolution, allowing employees to focus on more complex cases. And they will assess automation strategies of other public-private entities and conduct cost-benefit analysis for the IRS. At this point, They want to study the impact of the IRS research, applied analytics, and statistics outreach to increase the earned income tax credit participation by eligible taxpayers without children. A lot of taxpayers without children who are eligible for the ERTC are not claiming them. They're not aware it's there. Now, advocacy, they say, analyze the IRS's research, applied analytics, and statistics outreach program. Mailings, their mailing study, analyze its effectiveness. Look at cost-benefit analysis for further outreach potential policy to automatically issue ERTC where the IRS has sufficient information to determine these people are eligible. These research objectives directly support the broader goal of modernizing IRS IT systems, moving toward that digital-first approach, right? And ensuring taxpayers receive credits they're entitled to. Future outlook, potential challenges for 26. The One Big Beautiful Bill Act potentially could cause real issues. It could retroactively affect the 25 tax year. That could require the IRS to rapidly update their forms and have a lot more questions coming in for call volumes, right? And that's going to be a key issue. And the later that passes in the year, the more challenging retroactive fixes are going to be. Also, she pointed out that there's going to be a challenge in 26 because you're down by 1/4 of the workforce. That doesn't suggest that there are going to be huge improvements in customer service, let's say, taxpayers, calls, etc. The TIS recommendation for early preparation is to limit the hiring freeze and provide direct hire authority for taxpayer services, CSRs, submission processing employees by the end of summer. Not sure that's going to happen. And ensure adequate training for new hires they do have. Make sure the IRS continues to invest in modernization. Get the online accounts better. Get all paper digitized. And implement an integrated case management system under Taxpayer 360. The goal is to address systematic problems to transform taxpayer experience and uphold taxpayers' right, avoiding past issues like, quote from the report, tax season from hell. Yeah. So keep that there. Okay, finally, we have a court case here. This is a case, well, it was IRS motion to dismiss, and they got summary judgment on part, not on the other. But this looks at the issue of what is a responsible person and what's willfulness under the trust fund recovery penalty cases. Section 6672 of the Internal Revenue Code. This particular case is Warnament versus United States. This is from the U.S. Court of Federal Claims. Case number 21-2165. Decision came down June the 26th. The case offers insights into how we analyze, is somebody a responsible person, and were they willful? Were their actions willful in terms which could set them up as a party that's going to have to pay over the unpaid trust fund taxes, or at least one of the parties the IRS could turn to get that money. Remember, there can be more than one responsible person, and the IRS can collect from whoever they can grab the money from first. So it provides a detailed look at the burden of proof in tax controversies, which is relevant for tax clients who are in significant corporate roles. The trust fund penalty can snap at you even if you're in a role. You've got somebody who's in a role that does not itself appear to be a accounting CFO type role. But if you are using a title like, as will in this case, CEO, that implies you have authority over those things, and you suddenly could find yourself in trouble. Now, the penalty in this case is Warnament was assessed, basically the responsible person penalty under the Internal Revenue Code, Section 6672, because there were unpaid trust fund taxes in Engaged Networks, Inc., which is a now defunct, that's usually what we have the problem with, software and consulting company. Engaged failed to remit federal income and Social Security taxes, referred to as trust fund taxes. You'll hear that reference done often. Remember, income tax withholdings are trust fund taxes, and Social Security withheld from an employee's paychecks a trust fund tax. The employer portion of Social Security is not a trust fund tax. There were 7 tax quarters between July 2012 and March 2014 for which there are unpaid taxes, trust fund taxes, and those unpaid trust fund taxes amounted to over $609,000. The IRS has assessed the penalty against Mr. Warnemont, alleging he had a duty to remit the taxes due to his role and willfully failed by being aware of the delinquency and prioritizing other creditors. And this all began when Engage started to experience severe financial distress in 2021 after a major contract ended. Right? The company came under financial stress, the money became short, and that's usually how these start. Right? The money's short, and you realize that what people will shut us down today unless we get them a check. And while you understand that thought process, realize the IRS takes real time to react in these cases. And that's what lulls people into not paying the IRS and paying other people. And because the IRS doesn't need to be quick, they can go after any responsible person and try to get the money. Now, Mr. Warnemont's alleged role, because it goes back and forth where he was, from May of 2012 through 2015, he consistently presented himself as the CEO of Engaged Networks across various platforms. In his emails, on his LinkedIn, on his website, with his business cards, in board minutes, and when he signed documents. Now, he's going to tell us he really wasn't CEO necessarily for all that time, but it's there. Now, the government said he had control. They presented evidence that he exercised civic control, including approving disbursements, halting payments to attorneys, directing fund allocations, signing contracts and loan agreements for millions of dollars, and approving expenses, authorizing payroll, hiring and firing employees, and determining compensation. Now, Mr. Warnemont said, no. He didn't officially accept the CEO title in 2016 to avoid liability, claiming to be a consultant. He says his responsibilities were limited to sales, marketing, and securing funding, acting only at the board's discretion. Now, a key thing he does say, and this part is going to be one the court's going to, say, yeah, this could be key. He said he did not have check signing authority. Checks had to be signed by one of two members of the board signed all checks, Bacon and Clausen. He had to have board permission for any expenditure over $100,000. He also cited an instance where he directed an IRS payroll tax payment, but was then directed by other board members to stop it. And the board chairman, Gunther, and Secretary Clausen were actively involved in daily operations and controlled the finances of the entity. So Mr. Warnemont said, no, I wasn't CEO, and I really didn't have control over any of this stuff, in theory. Now, the legal standard for responsible person. As always, the taxpayer bears the burden of proof to demonstrate that the IRS determination is invalid. So the IRS assessment carries a presumption of correctness. So what is a responsible person? Under Section 6672 of the Internal Revenue Code, you have to extend beyond a mere mechanical functions test. Anyone, in fact, responsible for controlling corporate disbursements or who has the final word as to what bills should or should not be paid and when is at risk. The question is determined by a test of substance, not form. We look at the totality of the circumstances is what was going to be considered, and no single factor is determining. Now, some things would indicate responsibility. If you have check signing authority, if you are involved in day-to-day fiscal management, the ability to order payments to creditors, and your control over payroll. And final word means significant rather than exclusive control. More than one person may be a responsible person. There can be more than one. So it's, you can't just say that, well, somebody else did that, etc. If you fit this criteria, you can be charged as a responsible person. And the problem is the IRS can just collect from whoever has the bank account they can grab first. So, and we don't worry about the fact that maybe somebody else was more responsible. That's not a defense. If you meet that criteria, you can't say, well, somebody else is supposed to take care of that. You cannot use instructions from a superior to not pay taxes won't absolve you, if you're otherwise responsible. If you're ordered not to pay them and you go ahead then and pay other people, you're likely in trouble. As I've told people before facing this, it's like your job, once they tell you not to pay the taxes, is quit. It's not easy, but believe me, owing $609,000 is also not easy. Do you want to be unemployed and not have a $609,000 debt, because this thing is probably going down as this thing did? Or do you want to be unemployed with a $609,000 debt? Your choice. I would go without one. I'm just telling you. Yeah, you might get a few more paychecks, but you'll be paying those back. A person with apparent authority may not be responsible if they lack actual authority. So, or if the third-party control affirmatively prevents an individual from effectuating payments to the IRS. So again, you got to look at all the facts. Who really had control? What makes somebody willful? The failure to remit taxes was a voluntary, conscious, or intentional, as opposed to accidental. You're not required to have bad intent. Right? You're not required to show that you knew the taxes would never be paid. In essence, a reckless disregard of an obvious and known risk that taxpayer taxes might not be remitted is sufficient. Mere negligence is not enough, but if you have reckless disregard, and your problem becomes if you know the taxes aren't paid, they're unpaid. You generally, if you're a responsible person, have to go make sure they get paid. You can't just take somebody's word they're going to pay it. You got to make sure it's there. So you establish willfulness by evidence the responsible person had knowledge of payments to other creditors, including employees, after becoming aware of the failure to pay over withholding taxes. Did somebody else get paid while there are still unpaid trust fund taxes? So, really, there are two tests. Were you aware there was a delinquency? And secondly, did you favor other creditors over the IRS? And it's not a defense that funds were short, and if we didn't pay the supplier, we'd be shut down the next morning. That's not a defense. Even with limited funds, you have a duty to prorate, available funds between the government and the employees. Other creditors are tough luck. That's just the way it goes. Now, a taxpayer can overcome willfulness by showing they were unaware taxes were unpaid, they had a lack of reasonable opportunity to discover the delinquency and remedy it, or reasonable efforts were made to pay the taxes owed, but it just didn't work out for whatever reason. But again, your reasonable efforts, you can't say, well, the owner told me not to. Right? You really got to be careful there is what it was. Now, if the owner just simply yanks you off the checking account, and, from signing authority and, basically makes it only that person, and then that person takes over paying people, then they stop for paying taxes. But you got to be careful then of still determining who gets paid otherwise. That can cause you problems. On a responsible person, the court denied in part the government's motion for summary judgment. The court found there was a general dispute of material fact, which means we got to go to trial. It's whether Mr. Warnemount had the actual authority to pay the taxes owed despite the CEO title. Key factor creating this dispute was the lack of check signing authority. That was a big one. The evidence of board-imposed limitations on his ability to disperse funds and conflicting testimony regarding his autonomy versus others' control. Some testified that he wasn't really doing it, that others were running it. Other employees testified that he really did everything day to day. So they said, well, because of all of this, and there's lots of issues, we don't have enough evidence right now we can't decide based on this. So that is an issue that needs to go to trial, to be decided. So we're not going to issue summary judgment, on finding he was a responsible person. But was he willful? That the court will say, we got that decided now. Mr. Warnemount failed to demonstrate a genuine issue regarding his awareness of unpaid taxes and the fact he was aware of other creditors being paid. He has compelling evidence of awareness. He had explicit warnings. There was an email from Nugent, from Mr. Nugent, or Ms. Nugent, I should say, regarding that unpaid tax liability. Now, he claimed he didn't understand it. It was totally, he didn't understand what in the world they were talking about. It was accounting stuff. He really didn't get it. Consistent reporting, monthly cash schedule showed unpaid. And again, he claimed, I don't understand that stuff, right? And his admitted awareness of a significant tax liability in February of 2013. He said, this came back to haunt him, when he became aware there were unpaid taxes, his personal risk antenna really rose, but he didn't take steps to make sure things got paid after that date, right? The evidence overwhelmingly showed he authorized payments to other creditors. He authorized employee pay raises. He authorized new hires, hiring somebody going to pay them, right? He operating expenses after he knew about the deficiency. He didn't stop basically spending money. His attempts to rebuff willfulness were deemed inconsistent and unsupported. So the court, they said, if he is found to be a responsible person, the first issue, then automatically willfulness as a matter of law would exist. He can't get out of it under that. He's got to win the responsible person theory. So key takeaways on the trust fund recovery penalty. IRS assessments carry a presumption of correctness, so there is a substantial burden on the taxpayer to disprove both responsibility and willfulness. Remember that responsible person is about actual control. The titles are insufficient. Having one doesn't prove you are, and not having one doesn't prove you aren't. Actual control and authority over corporate disbursements are paramount. The presence of other individuals' significant control can create factual disputes. The problem that tends to happen here, though, is you get into a swearing contest because everybody's trying to claim that, no, I didn't have authority, he was in charge, right? No, she was in charge. No, they're just all finger pointing at each other, which eventually gets the court to make all of them were in charge, and so they just all owe this. That's the problem with the defense. Willfulness is defined broadly. Actual knowledge, knowing that payments are going to other creditors, will establish willfulness, irrespective of your intent. Claims of ignorance or misunderstanding, especially from financially sophisticated individuals, are unlikely to prevail. The court didn't believe he was that big of an idiot. It wasn't plausible. And inconsistent explanations by the taxpayer can severely undermine any attempts to rebut willfulness. It's very important to have documentation regarding notes, responsibilities, financial decision-making within distressed entities to determine and help you defend yourself against TFRP assessments. You've got to show that you didn't have the power to do it, or you've got to show that you were not aware of the underpayment. Those are going to be key issues. If the element of responsibility remains a question for trial due to conflicting evidence, evidence of willfulness can be so compelling that a court may rule on that as a matter of law, and now say the only thing at trial is if you had responsibility, then you are on the hook for the whole $609,000. That's the way it works. Well, this has been the Current Federal Tax Developments for the week of June the 30th, 2025. Current Federal Tax Developments, as always, is brought to you by your state society of CPAs. Again, my email address, edzollers@currentfederaltaxdevelopments.com. If you have any quick questions, you can pose them there. I also, spend time on the Connect sites for Arizona, Idaho, New Jersey, Illinois, and Washington, and Minnesota. So if you have any questions, you can post something there. And if I think I can help, I may answer. We'll see what happens this week. Again, theoretically, the deadline for us to get a bill would be the 4th of July, right? That's, in essence, we are supposed to have the bill all the way through the Senate and then actually pass both chambers, right? So in theory, it would appear, to be honest at this date, the bill that leaves the Senate has to be one that the House would rubber stamp, or the House or the Senate has to just give up on what they're doing and just pass the House bill, which I don't think they can do due to the bird bath problems. Certain provisions that were in the House bill have been struck, so the House would at least have to re-vote on their bill stripped of the bird bath problem provisions. It seems likely, the most likely outcome is the Senate, if we're going to get it by July 4th, the Senate needs to pass the bill that the House will then come back and pass, and that could get it to the president's desk by July 4th. I am I'm leaning at that. That's not going to happen right now. Sometimes they surprise me. Congress can at times move very quickly just out of the blue. I think, as I mentioned on previous broadcasts, being told years ago that Congress, has two speeds: glacial, which is their normal speed, and then speed of light, warp speed. Right? They go insanely fast, and you never know when warp speed's going to kick in. It doesn't kick in often, but when it does, it's so fast you're not sure what just happened. Probably discover that they actually passed everything while I was recording this. So we'll see. But in any event, assuming we don't have the bill next week, we'll talk about maybe where we stand in the process and any other developments. It will be a short week because of July 4th. So we'll see how many developments come out. But in any event, we will talk to you guys next week on current federal tax developments.